So, one of the questions that I get frequently is, do I have to have an attorney to file bankruptcy? And I think this is one of those questions where you should really consider the difference between can and should. And I'm not just saying that as an attorney. Technically, you can file bankruptcy on your own, but the American Bankruptcy Institute did a study a couple of years ago based off of the data that's kept from the bankruptcy courts nationwide. And what they found was that people who file bankruptcy on their own, less than half of them actually get to discharge in a Chapter 7, and only about 2% of them get to confirmation and a discharge in a Chapter 13. What this means essentially is that you are significantly more likely to successfully complete a bankruptcy, get to discharge, get to confirmation and a discharge, if you have an attorney than if you try to go it on your own. And there's a couple of reasons for this. First, an attorney that is licensed in your jurisdiction and practices in your jurisdiction, like I practice in the District of Maryland, is going to be intimately familiar with your jurisdiction's rules regarding the protection of your property. Secondly, they're going to be much more familiar with the nuances between a Chapter 7 and a Chapter 13 to make sure that you're getting filed into the correct case. I have several pro se litigants that come to me after they've already filed, and I typically have to convert them from one chapter to another chapter. So it's at the very least worth getting a consultation with an attorney in your jurisdiction, in your state, about filing bankruptcy to find out if that's right for you. But you are much more likely to get a discharge if you hire an attorney than if you try to do it by yourself.